Ladies and gentlemen, welcome. Give us a few more minutes while we're waiting for attendants to join, and we will start in 1 or 2 minutes. Thank you. So, ladies and gentlemen, welcome at this next episode of our Spring 21 webinars dedicated to the Whistleblower Directive and the impact on the HR function. Now, the Whistleblower Protection Directive aims at protecting and encouraging even whistleblowers throughout the European Union who report on a range of misconduct that they become aware of through their workplace. As you know, at the end of our session, we will have a Q&A. So at your right upper side of your screen, you will find the button to press, and you can leave your questions out there. As there are quite some data protection and privacy issues with this subject, we have invited a special guest. Tim van Kanijt will join us, a partner in our tech outsourcing and privacy department, and he will look more precisely into these aspects of personal data, data processing, etc. And you have the usual suspects, Tim Perdiers, Senior Associate, and myself. Ladies and gentlemen, just to introduce today, you will certainly remember the LuxLeaks, where a whistleblower brought up the fraud that was being made by several banks. Maybe you have read about this scandal in the United Kingdom, where fraud was being perpetrated on masks for the COVID-19 to protect the nurses and other people for the COVID-19 pandemic. But very recently, and very closer to home, the police officer stating that he has been retaliated because he was denouncing the violence of his colleagues. And although from the police and within the police department there exist specific rules and regulations in respect of whistleblowing and rules against retaliation, it is not the case in the private sector. And one of the examples, very recent example, is being demonstrated by case law, a case of the Court of Labor in Antwerp, the 28th of January 2021, where a union representative refused to work any longer at the workplace because asbestos was being discovered at the workplace. He refused to go to work and he was terminated for a grave misdemeanor. He went to court and he had, in fact, to state and to demonstrate that the fact that he left the workplace was not a grave misdemeanor, that he had been dismissed for an unreasonable reason, and furthermore, that he had been discriminated against, at least prima facie, at least he had to bring a beginning of proof of the discrimination. So Three elements he had to prove: a long process and very low damages at the outcome of the procedure. Just to demonstrate that probably some legislation is needed to protect, specific legislation to protect those what we could call heroes in our daily life. Now, this has not been unnoticed for the European legislator, and also this legislator has given increasingly attention to the recognition of whistleblowers as an essential source of information on wrongdoing. And whenever, at the moment that this directive was being brought forward, drafted, only 10 countries had a specific legislation. Now, thousands of companies will probably be impacted by the directive, the initiative the European Union took, a directive which is indeed becoming applicable as from, or needs to be implemented in national legislation by the 17th of December 2021. It was entered into force, or it came into force on the 16th of December 2019. But now the time is indeed running fast, and the national legislator promised that it should implement the directive in time, so by the 17th of December 2021. No legislative text is yet available. Nevertheless, companies can certainly take some action, and that's what we are going to discuss, premature action, just to be ready whenever that legislation is going to be effective. Now, as a general obligation, companies will have to set up a reporting channel of companies employing 50 workers. There is a little transition period for companies between 50 and 249 workers. There, the legislator might enact some legislation later than the 17th of December 2021, but needs to do so by 17th of December 2023. Now, what is it all about? Well, in fact, the whistleblower will be able to receive a protection whenever he is communicating an act or an omission which are unlawful and which is against the policies, the legislation of the European Union. So, for instance, legislation of processing of data, GDPR, whenever an employee at the work floor notices that an infringement is being made, he can denounce it and he will be protected by the directive, national legislation per state. It's not only an act or an omission, it can also be the knowledge of future acts. It can also be the knowledge of an attempt. And it doesn't need to be a major infringement, it can also be a minor infringement. Furthermore, the Belgian legislator can extend it and can also make it applicable to the infringement of Belgian legislation. So that is certainly something to watch. Now, what is it about? What can he, or which infringements can he indeed denounce? Well, infringements on rules of public procurement, financial services like terrorist financing, money laundering, product and transport safety, wearing masks, nuclear safety, public health. The European Union has provided for some rules in respect of the COVID, but also legislation in respect of the environment, protecting the environment, treatment of personal data, and not only the personal data in itself, but the protection of networks and IT platforms are within the material scope of the directive. And again, as I said, Belgium can extend this scope. Now, employment law is not specifically in the material scope of the EU directive, because the legislator stated, the EU legislator stated, that there are other channels to report on it. Like, for instance, via the union representative, the hierarchical link with the employer, workplace doctor. Nevertheless, I think it is certainly important to see it in a broader view and to look at the impact of the directive on the one hand, in respect and the interaction between the directive and the implementation and the policies already of application in the company, which protects then specific employment law legislation. Well, whistleblowers can be of a different kind. It can be the employee working in a subordination for an employer and receiving the remuneration is the most obvious, clearly, but also the employees of the service provider, directors of a company, students, stagiaires, volunteers, and even ex-employees or employee candidates can benefit of this specific protection against or specific protection given to the whistleblower. Now, what other persons are within the personal scope benefiting of this directive and then later on of the implementation of the legislation? Well, facilitators like the union representatives, for instance, colleagues, and eventually even family members. Family members, although it might be difficult that you to prove and to evidence that you have been terminated because a family member has been a whistleblower. But we will look upon this because the legislation or the directive also gives some or will help the whistleblower to be able to prove or to evidence that the whistleblower has been, for instance, retaliated or acted against. So without any further delay, let's look about how the whistleblower should report the infringements, the acts which are unlawful. Tim.
Thank you, Stefan. We will indeed address now what this means in terms of reporting, in particular for private sector employers. The directive requires setting up safe channels for reporting on different levels. First of all, there are the internal reporting channels. These have to be organized within the organizations themselves. Then you have also external channels for reporting to public authorities. The obligation to organize this falls on the member states and not on private companies. Lastly, reporting can also be done to the public at large, for example, through online platforms and social media. Today, we will of course focus mainly on the requirements in relation to internal reporting, as this directly concerns employers. Indeed, the directive provides for an obligation to create internal reporting channels and appropriate procedures. For the public sector, this concerns all public legal entities and entities under their control, but an exception can be provided for entities with less than 50 employees or for municipalities with less than 10,000 inhabitants. For the private sector, a threshold of 50 employees applies under the directive. Companies with at least 50 employees will have to create appropriate internal reporting channels and procedures. Member states can decide to apply a lower threshold for specific matters, subject to risk assessment, for example, for food safety or when activities pose significant risks for public health or for the environment. Also, for certain types of financial services, no minimum threshold applies, and the requirement to implement internal reporting channels already exists under other regulations. The directive itself does not provide guidance on the calculation of the threshold. Looking abroad, for reference, the Netherlands have already adopted rules on whistleblowing and apply the threshold of 50 employees. For Belgium, as a reference, it could be considered to refer to the calculation manner as is applied for small companies in the Belgian Companies and Associations Code. Which takes into account the average number of employees in full-time equivalents based on Dimona declarations. A similar reference could be made to calculation manner for the organization of social elections. Ultimately, it will of course be up to the legislator to provide the rules, and in that regard, again, Belgium can choose to apply a lower threshold. As Stefan mentioned, the legislator can decide to postpone these obligations for private companies with 50 to 249 employees until 17 December 2023. This is not possible if you have more employees. The directive requires the creation of these efficient and effective channels and procedures, both for internal reporting, but also for the follow-up of reports. These channels and procedures must provide appropriate warranties in respect of security, confidentiality, record retention, and processing of personal data, in which respect, of course, also the obligations under the GDPR will apply, on which Tim will elaborate further later in this webinar. When implementing the directive in national law, the Belgian legislator can, of course, still impose further conditions. the directive also highlights the role of the social partners in the creation of internal reporting channels in the company, but again leaves it to the national legislator to determine requirements in terms of their involvement and any obligations in terms of consultation and information. We, however, consider in any case for Belgium that the Works Council will have to be informed and consulted, or in absence, of course, the Committee for Prevention and Protection at Work will have to be informed, or if there is none, the trade union delegation. But this can be addressed further in the implementing legislation. Looking at the actual reporting, it's important to know who and of course who can and who should be able to file a report through the internal channel. Of course, own employees can file reports. The text of the directive also indicates that it can be open to other categories of persons, such as self-employed workers or employees of subcontractors, but the wording of the text suggests that this is a possibility and is optional. Looking, however, at the considerations of the directive, it's clear that this is much broader and that employees of group companies can report as well as groups, agents, suppliers, and basically any person who acquires any information through their professional activities in relation with the company and the group. So this is quite broad. The internal channels must allow reporting in writing or orally, or can provide for both. Oral reporting can be organized through the telephone, hotline, or voice messaging systems. And upon request of the reporting person, a physical meeting must be possible within a reasonable time frame. This possibility for face-to-face reporting is a requirement. Written reporting can, of course, make use of post, emails, or even a physical reporting mailbox, or as is most commonly the case, of course, the platform, an online reporting platform. A fundamental principle of the EU framework is confidentiality of the identity of the whistleblower and of other persons mentioned in the report. Information on their identity should be shared only on a need-to-know basis. This also extends to any elements that could lead to that identification and applies in any stage of the process, both in the context of reporting itself and in the investigation phase. The channel must be set up and managed in such a way that it provides appropriate guarantees in respect of security and confidentiality. Exceptions to this principle apply, such as in event of explicit consent of the whistleblower or where the whistleblower consciously makes an identified public reporting. Also, when necessary and proportionate to comply with legal obligations, also with regard to the right of defense of any involved persons, a disclosure of the identity of the whistleblower or of other involved persons can be justified. In such event, appropriate warranties must be put in place, and the person should be informed before the disclosure of its identity, unless this would, for example, put at risk ongoing investigations or proceedings, and the reason of the disclosure should in any case also be notified in writing. One may think it would be a lot easier just to make an anonymous report. Anonymous reporting was in the past frowned upon in many jurisdictions, but the directive now allows it. However, at the discretion of the member states, who can decide on this and can decide differently. It's not yet known how Belgium will specifically approach this. As a reference, in France, anonymous reporting is now possible, provided that a certain number of conditions are met. Taking into account difficulties for screening and follow-up of reports, anonymous reporting should, however, not be encouraged. In terms of process, once a complaint is received through the internal reporting channel, acknowledgement of receipt should be sent within 7 days to the whistleblower. The report should then be followed up diligently by the responsible person. The directive does not provide much detail regarding the manner in which filed reports should be treated internally. This can again be developed further under Belgian law. Feedback on the report should be given within a reasonable term and at the latest within 3 months after acknowledgement of the receipt of the report. The feedback can concern information on the measures taken or planned. For example, even just the fact that the case is closed due to lack of evidence or is referred for further investigation, or on direct measures taken to stop any reported abuses. The report should be managed by an appointed, independent and impartial person or department who can be internal to the company, such as the compliance officer or HR, but can also be an external one, an external reporting platform, for example, that must then, of course, also provide sufficient guarantees in terms of independence, security, confidentiality, and data protection. Important to note is that companies with 50 to 249 employees may pool their resources for receiving and investigating the reports. This is not possible if you have more employees, and then you have to create your own independent scheme. When a report is made, the directive requires that a recording or at least complete and accurate written transcripts have to be made and kept. Transcripts must be able to be verified, amended, and signed by the whistleblower as well. Both regarding internal and external reporting channels, information duties apply. The information must be easily accessible also for those non-employees that can make use of the system. For example, it can be posted on intranet or can be incorporated in any policies, and trainings can be given. In any case, regarding information to be given, also the notification obligations under the GDPR regarding processing and use of personal data in the context of whistleblowing schemes will apply, on which Tim will elaborate further. Regarding the format to implement a whistleblowing policy in your company, there are multiple possibilities. In principle, this could be done through an employer policy, but it could also be included in the work regulations. This, however, provides much less flexibility due to the formal procedure that needs to be respected for modification. Also, on this point, it's possible that the legislator will provide specific instructions. As indicated before, information and consultation duties apply. And also the legislation on use of languages will apply, which requires use of Dutch or French, depending on the location of the place of business to which the employee is attached. As indicated, we will not go into detail today on external reporting, as this is organized by the state. It's however interesting to note that there is no formal requirement for the whistleblower to first make an internal report before an external one. Use of internal procedures should, however, always be encouraged. The same applies for public reporting. There, however, protection of whistleblowers is conditional on listed reasons why another manner of reporting did not suffice or would not be possible or sufficient. Lastly, as Stefan mentioned, the creation of these reporting channels does not affect other existing possibilities and procedures for reporting, such as the specific procedure in Belgium for moral and sexual harassment, violence, psychosocial burdens at work, or any direct hierarchic reporting, consulting with employee representatives, trade unions, or to turn directly to inspection services, the police, or the courts. And then Stefan will address the retaliation further.
Thank you, Tim. Of course, whenever a whistleblower is going to make public some information, confidential, non-confidential, but the fact that there is an attempt or there is an infringement of that legislation, some protection needs to be given in respect of retaliation, in respect of termination of employment, etc. So member states, according to the directive, need to take measures against retaliation to protect the whistleblower as a person. Now, the directive gives also a definition and defines it as any direct or indirect act or omission which occurs in a work-related context, is prompted by internal or external reporting or by public disclosure, and which causes or may cause unjustified detriment to the reporting person. Now, for Belgian legislation, this will quite have a substantial impact because we don't have any legislation against retaliation so far, and so as such for whistleblowers, so certainly will have an impact, not negligible. Now, what are we talking about? What are the conditions to be able to benefit from this protection? Now, in order to prevent someone from making malicious reporting or abusing on the possibility of protection of a whistleblower, the information needs to be based on reasonable grounds, and it needs to be reasonable grounds to believe that the information reported was accurate and within the scope of the directive or the national legislation, if the legislation would extend the scope, the material scope of the directive. And the information must have been made public, anonymous, non-anonymous. So these are the two conditions. If those conditions are fulfilled, the whistleblower is protected against measures of retaliation. What is now retaliation? Well, we can think about suspension, dismissal, demotion, refusal for training, intimidation, negative evaluation of the employee, non-extension of an employment contract for a limited duration, premature termination, reputation damage, etc. Now, of course, this is not easy to prove, and as such, the directive and the national legislation ultimately will help indeed to be able to, for the whistleblower to prove or to make his or her point. First of all, as a protection, there will be a limitation of liability of the whistleblower. Whenever information is being made public, even if that information is confidential, the whistleblower will not be held responsible for making private, confidential information public. Of course, that information must be of importance for the announcement or the whistleblowing eventually. If it is only information which is superficial, not important, and making that confidential information public, that will not be falling within the scope. Reversal of the burden of proof. We have such a mechanism in our anti-discrimination legislation today. It means that whenever a whistleblower has made a report and he or she is confronted with a disadvantage, detrimental fact, so a retaliation element, well, it's sufficient to state that there is an element which is quite negative, which is indeed a disadvantage, to conclude that it is a retaliation. It is then up to the one who applied the detrimental act to prove that it was not a retaliation. So the reversal of the burden of proof. And then recovery measures. The employee or the whistleblower will be able to ask for reimbursement of costs, legal costs being made, economical damage eventually, medical or moral damage which he or she incurred, reintegration if the national legislation will provide for it, and even it's feasible and thinkable that the legislator will also put in place special mechanisms to be able to stop immediately, to go to court and to stop immediately the retaliation being performed vis-à-vis the persons. And this indeed is also another measure accompanied by the fact that people who will inform or will assist, like for instance a union representative, will also be protected against retaliation. So also for people who are informing or assisting the person concerned, the whistleblower. Let's have a look at the sanctions then.
Yes, very short. It will basically be up to the Belgian legislator to provide and to implement effective, proportionate and deterrent sanctions. The directive itself does not provide for any specific level. Sanctions should apply for obstructing or attempting to obstruct the reporting itself. For retaliation, it's not prohibited. It's not permitted. For any vexatious or for intentional incorrect reports, and also for breaches of confidentiality of the identity of the whistleblower. The directive itself does not point to the protection of the identity of other involved persons, but this can, of course, be provided under national law. Next to sanctions, claims for damages, of course, also remain possible, as well as claims under other national legislation, such as discrimination or manifestly unreasonable dismissal. So very interesting to keep in mind as well. And then I think that we will pass on to the data protection aspects addressed by Tim.
Okay, yes, thank you very much, Tim. So as the other Tim mentioned, the directive requires organizations to comply with the principles of the GDPR as well. And so the question is, what does it mean exactly? And that's what I'll try to recap in the next few minutes. What you should bear in mind is that there is currently no specific data protection guidance that specifically addresses the whistleblowing directive, but we do have quite a bit of old guidelines. First of all, some guidelines that go back to 2006, the Working Party 29, which is the predecessor of the European Data Protection Board, and the Belgian Privacy Commission issued opinions. And although they are interesting, obviously they date from before the effective date of the GDPR. But we also have more recent guidance from 2019 issued by the French Data Protection Authority, the CNIL, and also the EDPS, the European Data Protection Supervisor. Now, what are the key attention points? First, I would say, as with any processing activity, you need a valid legal basis. And for whistleblowing, basically, it should either be a legal obligation to process data in the context of whistleblowing, or your legitimate interest as employer. In the past, actually, many US headquartered organizations in the EU wanted to rely on the US Sarbanes-Oxley Act as a legal basis, a legal obligation. But the issue is that that was and still is not allowed. It's very clear that the legal obligation that might trigger the whistleblowing must be an obligation that stems from EU or member state law. And so obviously this directive and the national transpositions will be very helpful in this regard, as they will give organizations that legal obligations. Now, even organizations that are not legally required to implement a hotline under the directive might still want to do so. And so it's good to know that they could still decide to do it on the basis of their legitimate interest. Obviously, in that case, it will be important to conduct a legitimate interest assessment because you have to be able to demonstrate that your interest as an organization is not overridden by the fundamental rights of data protection of the employees, basically. And so, as you will see, consent is typically not considered an appropriate legal basis for whistleblowing hotlines, pretty much as it always is the case in the context of employment and HR data processing. So if we move to the next slide, you will see the data protection principles, which are obviously very important and need to be complied with, just as it is the case with any other processing activity. Just a few specific points that I would like to raise here. You will see the principles of fairness and purpose limitation. They are obviously quite closely linked to the prohibition to retaliate, and I won't go into further detail. This has been addressed already, but just bear in mind that they're linked. I think more interestingly, the principle of data minimization is a very important one in the context of whistleblowing. Basically, if the report that you receive as an organization contains information that is irrelevant to the case that you have to investigate, the expectation is that you should not store it in your file. You should delete it immediately. Also, bear in mind that with regard to anonymous reports, and as you heard, the directive allows anonymous reporting, but the position of the data protection authorities currently is still that you shouldn't encourage people to report anonymously, which is contrary to the common position in the US. So if you're part of a US headquartered organization, that remains a difference in approach. And then obviously data minimization is also relevant when you share data about the whistleblower in an anonymous way when you conduct your investigation. Just bear in mind that the information is truly anonymous. It may not be enough to simply remove the name of the person. If this person is working in a quite small department, for instance, there's many other elements that may indirectly identify the whistleblower, and you have a duty to ensure that that is not possible. Another interesting principle is storage limitation, the principle that you should not keep data for longer than necessary. According to the French Data Protection Authority, for instance, if you close the investigation because the alleged facts don't seem to be substantiated, so you don't take any further action, well, then there is an expectation that you delete the data within 2 months following that decision. Obviously, if you do initiate disciplinary or judicial proceedings, you can keep all the data that is relevant until at least the end of the procedure, and or potentially also until the statute of limitation is reached. And then obviously there is the accountability principle, but I'll come to that in a separate slide. I would now like to first discuss transparency. Transparency as you probably know, is a very important principle under GDPR. Data subjects must know what you as an organization do with their data. So you have to inform the people that are concerned about the whistleblowing. How do you do that? Well, you have to do it in separate ways. The first level of information is when you roll out your whistleblowing hotline. At that stage, you will need to provide a general notice to all staff. That notice must inform staff members on how the system operates, who is able to access the report, do you rely on third parties or not, etc., etc. But it's not enough to do it with this general notice. For instance, the CNIL expects, and the EDPS as well, that you repeat that information when the whistleblower wants to make a report. So, for instance, when they log on to the IT system to file a report electronically, there should be a notice that appears on screen which repeats that information. If you use a hotline, an automatic message should be played before they can make the report, etc. And the EDPS actually also recommends that after the report has been filed, the whistleblower should receive, ideally by email, a copy of this privacy notice with all the relevant information. And then finally, when we speak about the whistleblower, there is an expectation, again, this is the point of view of the CNIL, that when you close the investigation, you should inform the person on what you have decided. But obviously, it's not just about the whistleblower. There are many other persons concerned that also have the right to be informed. And I think here it's important to bear in mind that we're not only talking about the alleged perpetrator, but also potentially about victims or witnesses that have been mentioned in the report. All those people have a right, and you have an obligation to inform them about the report and the facts that have been reported. And that information must be provided within a reasonable delay, according to the data protection authorities, unless, of course, informing them too soon might jeopardize the investigation. In those cases, you will still have to report and to inform them, but you can postpone that provision of information. And of course, as mentioned, you should not disclose the identity of the whistleblower. The obligation of confidentiality is crucial. So that brings me to the next point, which is accountability. And as I said, it's a crucial new concept under the GDPR. When we speak about whistleblowing, what does it mean exactly? Well, it basically means three things, I would say. First of all, you will have to conduct a DPIA, so Data Protection Impact Assessment, before you roll out your whistleblowing mechanism, in which you assess the risks for individuals, so staff members, both the whistleblower and the people who are the object of the report, and you implement measures to avoid that their rights are harmed too much. Secondly, you will have to create a specific line or an entry in your register of processing activities that specifically deals with the whistleblowing hotline and how it operates, which data you collect in that context, with who you share it, etc., etc. This should sound quite familiar because in HR you should have quite a few registers and entries in the register. And then finally, you should be quite careful when you rely on external service providers, which is often the case with whistleblowing. First, before you contract with them, check and ensure that they comply with GDPR, especially if they're not EU-based. And when you do contract with them, make sure that you put in place the mandatory data processing agreement. And speaking of third parties, that brings me to the last point, which is on international data transfers. It's a topic that I could easily spend a whole day on, which won't be possible here. So what I basically want to say here is the following. In my experience, a lot of the external whistleblowing service providers are US based, and it's, let's say, a US invention, so that's not a normal as such. But obviously, as you may have heard since the Schrems II decision of the Court of Justice of the EU, you can no longer rely on the EU-US Privacy Shield to transfer data to those US service providers. And also, the Court of Justice ruled that the US basically does not provide an essentially equivalent level of data protection compared to the one that exists in the EU. And what it means is that when you sign so-called standard contractual clauses or model clauses, as they are often called as well, it doesn't suffice, as it was in the past, to just sign them and then put the contract in a drawer somewhere. You have to implement supplementary measures to make sure that the data remain protected in the US against snooping, basically by US intelligence services. It is something which is not easy to achieve because quite often the only solution is to encrypt the data that you send to the US in such a way that the recipient is not able to decrypt it, which obviously defeats the whole idea of involving this third party. And so in some cases, it may actually make your life simpler to try and find an alternative provider who is based in the EU. But in any event, if you rely on US providers, make sure that you implement those supplementary measures. And that is, in a very short nutshell, the main attention points, I would say, from a GDPR perspective. With that, I hand back to Tim or Stefan.
Thank you, Tim. Yes, to end, you will have seen that the directive is already quite giving some details, and some elements will have to be addressed by the Belgian legislator, obviously. But you can still, and you can already, indeed, take or undertake some actions. And we have listed a few ones here for the HR function. First of all, the directive doesn't cover reporting on wrongdoing in certain areas of employment law, so make sure that you have those channels in place, if not yet, and review the ad hoc internal complaint channels, because indeed some elements might have to be adapted in interaction with the directive and the legislation to come. Determine the source of law. Probably different sources of law will be provided for by the legislature, or it will be possible. You can think about workers' regulations, the unilateral company policy, as Tim already mentioned. Review also the labor regulations in respect of sanctions and other elements that are addressed and that interact with the whistleblowing directive. Also very important is to detect and to audit the offenses from a labor law point of view, do an employment law, social security, immigration and tax audit to prevent some employees to make a complaint, because you would be fully compliant from a labor law or employment law perspective. Manage the complaints channel, and of course also think about the involvement of the Works Council already, the Health and Security Committee, the union representatives and their role, and also how you are going to inform the employees individually about this policy being put in place ultimately before probably the end of the year. Some general observations. Belgium obliges the language regulations, of course, but also to look at sufficient warranties, and Tim has been talking about, Tim van Canet. The procedure to file the reports, etc. These things are all certainly already elements to think about before even the legislation is applicable, because the directive is quite clear on certain aspects. Well, as a conclusion, we wait all for the Belgian government legislator to implement the directive. And in the government declaration, it was stated that they would do that within the deadline. Let's see what this will bring us. But as I said, it is already fairly comprehensive, and you can already undertake some actions in respect of the implementation. Furthermore, as I said, it will have a major impact from an employment law perspective, retaliation, reversal of the burden again, of proof again, which we already know from the discrimination legislation. All these aspects will certainly have an impact on employment law in the next few months. I do not detect any questions in the box, if I am correct. I'm just checking.
There are two questions, Stefan.
Oh, sorry, I am difficulties in viewing them. Maybe, Tim, you can just raise them.
Yeah, so first question is whether infringements to competition law are also in scope of the directive. I think indeed the material scope of the directive also extends to breaches of union law, also in respect of non-competition, so competition law and state aid. I don't know if you want to add.
Just to add on this, the directive itself gives an exhaustive overview in the annex to it of all the legislation that is indeed focused on by the directive, so that which legislation, European legislation, is covered by the directive.
And another question that was raised is, did I understand correctly that we have to delete a file if the report was not substantiated or considered as plausible? That's a question, I think, for Tim. Tim?
Indeed. So the answer to that question is that it is indeed the expectation of the data protection authorities, and it's a bit a logical consequence of the principle that you should not store data for longer than necessary. So if you receive a report, you do your initial investigation and you conclude that it is unfounded, that there is no evidence of any wrongdoing, then the file should be closed and all the information related, all the personal data related to that alert should be deleted, because it's no longer needed and you can no longer justify keeping it.
Yeah. A last question just on the line, I would say, on the end. Do external non-employees also have to access the platform for whistleblowing? We now have an app for employees only. Indeed, based on the text of the directive. Now, this is of course subject to implementation in Belgium by national law. A large number of non-employees should also be able to make this complaint. The directive itself seems to provide for an option to extend it to that, but in the considerations, it's fairly clear that the intention is to make this a lot more broad than just employees only. So to have a final answer, we'll have to wait for a final implementation in Belgian legislation. But it's indeed to be expected that it will be broader than just employees.
Yeah, the directive already gives a few, in the personal scope, a few other categories of persons, if I can call it this way. It's ex-employees should have access, but also the employees of a subcontractor. So whenever you ask a subcontractor, a service provider, to provide some services to your company, the employees of the service provider should also have access to your whistleblow line. So indeed, it is not limited only to employees. Of course, people who are totally external to the environment have other channels also to be able to report. For instance, you could also think about filing a complaint to the social inspection, for instance, or eventually advise the union representative in the company, who then will deposit a complaint. So it is certainly more broader than the employee stricto sensu, and the directive already gives a number of categories, which can be, of course, supplemented by the national legislation. Okay, no further questions. Thank you very much for your participation, interactivity, because very interesting questions. And well, I'm concluding this session by inviting you to our next webinars on health and security at work, and then specifically with a chapter on COVID-19 and safety at work, the diversity policy and legal aspects, how to draft it, but also what are the legal aspects surrounding it. And then in July, the travel time and working time, the latest update on that topic. Thank you very much for participating. Wish you a very good day and stay healthy. Thank you. Bye-bye.